I'm just making sure that there's not still Coca-Cola flowing all over the table over there. Okay, we're back on. Council present and defendants present, represented by counsel. We are discussing on page 19 the contemporaneously language. So tell you how the court's going to charge this. I don't read the statute the same way as the defense. I read into the statute. The first line addresses both felonies and misdemeanors. The second sentence narrows that then down to felonies. It doesn't discount misdemeanors. It just says in the case of felonies, if there's an escape going on, then the arrest can be effectuated. The way I read that is if it's a misdemeanor, the guy can be arrested, guy, gal, whoever it is, can be arrested by whoever is effectuating the citizen's arrest. But if they run, then you can't go chasing after misdemeanors. In the case of a felony, you can. And a person who is chasing somebody who's escaping on a felony that is justified upon reasonable and probable grounds for suspicion can effectuate the arrest. So the charge that I am going to provide, I'm going to amend a little bit from the state's language, and that is that a private citizen's warrantless arrest must occur immediately after the perpetration of the offense or, in the case of a felony, during the escape. If the observer fails to make an arrest immediately after the commission of the offense or during escape in the case of a felony, his power to do so is extinguished. I'm not going to comment on the legality or illegality, so I'm putting a period at the end of extinguished and removing the "and a subsequent arrest is illegal." So, again, private citizen's warrantless arrest must occur immediately after the perpetration of the offense or, in the case of a felony, during escape.
I'm sorry, could you say that last portion again?
Or in the case of a felony, during escape. If the offender fails to make the arrest immediately after the commission of the offense or during escape in the case of a felony, his power to do so is extinguished. That's what the court intends to charge. I understand there's an exception from the defendants.
Judge, if you charge the jury the way you're contemplating, you are directing a verdict for the state. You are rendering the second sentence in which it describes reasonable and probable grounds of suspicion meaningless. It's in there presumably for a purpose. It's a different burden than immediate knowledge or presence. And so I would urge the court to reconsider and eliminate this, let the state argue what they're going to argue. We have built this whole case around the probable cause, the second sentence, last phrase that Travis McMichael and Greg McMichael had on February 23rd for events that happened previously. And you are gutting all of it if you give this particular charge.
May I ask, Your Honor, if, I know we're Friday at 2:30, if over the weekend we were able to email to you or your staff a full, complete with citations argument for what position we're arguing for here, that this contemporaneity of the offense for which you are fleeing and being chased.
Why don't we do this? This is what I intend to charge. I'm not going to reopen all of the charges. I understand the significance of the charge that is presented. I will, if I'm provided something, at least on a